first-degree murder conviction. Mr. Nunez shot and killed his wife in a apartment parking lot. There's no dispute as to that. They had been in an argument about infidelity that had carried over hours or minutes or hours. The argument in the parking lot occurred while she was sitting in her vehicle. He had gotten out of his truck, was talking to her. At some point she disengaged, rolled up her window. I think it's fair to say that he lost it in response, quickly retrieved a gun from his vehicle, which was sort of within reach, broke the window, threw her phone, and fired 6 shots, I believe, that killed her. He then drove off sort of in an erratic fashion, called his mother in a state of emotional upheaval, made arrangements to drop off kids that were still in the car with him, drove into Kentucky, was on the phone with a coworker who could tell that he was, Mr. Nunez was in a state of upheaval, and ultimately is stopped by law enforcement. There's sort of a low-speed chase for about 3 miles. Mr. Nunez stops. The officers then start talking to him. He says he can't hear them. He drives off and crashes. After that, is taken to the hospital. So that's sort of the factual summary. The evidentiary issue I'd like to discuss, and I've argued this, I think, 4 separate ways. I want to argue it 2 separate ways today. The issue relates to statements that Mr. Nunez made in the hospital to the nurses. So this is about 5 hours after the shooting. He has made his way to Kentucky. He has been on the phone with mother and coworker. He has crashed. He's gone to the hospital with injuries and talks to the nurses. He makes a number of statements that are recorded in the medical records. They're all sort of similar in nature. I can't believe I let it get all the way to this. You have someone you love. You have to love them even with their flaws. I messed up tonight. I really messed up. I've effed up my life and my kid's life. I hurt my baby girl. She didn't deserve that. No matter what she did, she didn't deserve that. I hurt my baby girl. She cheated on me and I lost it. It's my son's birthday. I can't believe I did this. So sort of that kind of statements that are notated mostly verbatim, at least purporting to be verbatim in the notes. Defense sought to admit these. There's discussion of them coming in, and the trial court excluded them. There are 2 hearsay bits at issue. I think on appeal there is no dispute that the records themselves were authentic and authentic business records. So the fact the nurse wasn't there to testify, I think, is not at issue. What is at issue, though, is whether or not Mr. Nunez's statements to the nurse, the sort of first half of the hearsay analysis, whether that was inadmissible hearsay or instead falls under an exception to the hearsay rule. We've asserted a number. I'd like to argue 2. The first, and I think the most straightforward, is excited utterances.
All right, I had a question about that. Excited utterance says somebody who makes a statement under duress or excitement from the event. That's my paraphrase, but that's basically it, right?
Yes.
So your theory, I assume, from reading your brief, is he was, and your argument here today, he was still under the, I guess, excitement and duress of the shooting, and here he makes these statements 5 hours later at the hospital, right?
That's correct.
Okay. Now, he's on video going to the Walmart buying clothes and underwear and socks at some point between the shooting and the wreck in Kentucky, right?
Yes.
Okay. And at some point he stops either in Rocky Top, Tennessee, or in Kentucky and he buys alcohol and he consumes it because he's drunk when he wrecks the car, right?
He buys alcohol. I think it's certainly reasonable inference he consumed it, yes.
Okay. So it is your contention, even with those intervening events, that he was still under the delirium or the excitement of the shooting 5 hours later?
It is.
Okay. All right.
And to that, I would point to a couple of things. Point to the unchallenged testimony of his mother, which talking about she was on the phone with him while he is driving, and she describes sort of, he's talking to himself, he's sort of making all these strange statements. She's very worried about him. As soon as she gets the kids, she calls 911. He calls his coworker, talks to him, and sort of the same thing. The coworker can tell something is so wrong, the coworker calls 911. I think you have excited utterance, you have a startling event. I wouldn't think there'd be a doubt that this is the argument leading to the shooting, even if he perpetrated it. That is a startling event. I believe his excitement continues through this time period, and he is at the hospital. He's talking about that event. This issue, the trial court basically decided the time was too much, that 5 hours he's gone to another state, it can't be an excited utterance. The issue is somewhat fresh in my mind in the sense that this panel of this court recently affirmed a excited utterance by a rape complainant in Joshua Stephen Sullivan, where it's about 18 hours. And in that case, there was allegation of a rape. There was no proof whatsoever as to what happened the following day and that night. And then the following night, 18 hours later, the complainant is upset and makes statements. So, as I said, it's a little close to me in that I lost that case. But this is, I think, a much shorter time period. We have information as to what's happening in the interim. I don't know that that's necessary, but we certainly have it here. And then the state has contended on appeal. Basically, there's nothing, he's not excited at the time he's making this, whereas the nurse's records refer to him as unable to be consoled and sobbing uncontrollably. So that's the excited utterance argument. The second argument, equally, I think, justifies all of this, is 8033, the existing mental, emotional, or physical condition. And the point that I think that the trial judge didn't grasp, and maybe I didn't make it so that the state could grasp, the point of introducing this information, his statements to the nurse, was not to prove the truth of prior events. The defense was not introducing this to prove that he shot his baby girl and that she didn't deserve it. Right? That's not the purpose of it. What they were using it for was to show his emotional state, how he felt about it. And that's what that hearsay exception is for. You're not proving a prior fact, you are proving how someone is feeling, their emotional state. What is interesting here, the reason this comes up, is most cases, let's say this carefully, most cases we don't care what someone feels about a crime after it's over. If I rob a bank and then I feel bad about it or good about it or whatever, that's entirely irrelevant 5 hours later. That's different for first degree and second degree murder, because the Supreme Court in the Bland factors specifically talks about you have to look how they act after the fact. Calmness after the event is something that is relevant to whether there's premeditation or not premeditation.
Let me ask you a question, though. That you can have people that are pretty fired up that go out and commit a homicide and planned it for 3 or 4 days ahead of time, are all fired up about it, are still fired up about it afterwards, and that would not be a problem with premeditation. So the fact that the defendant was upset 9 hours later wouldn't contradict the fact that he premeditated the killing, would it?
I don't think it's dispositive in and of itself, but it's something that is relevant to the analysis. I think there's a Supreme Court case called Leach. I didn't cite this in the brief, but it's 2004, where one of the things that was said to support a premeditation finding was that after a shooting, the defendant went to Missouri, where he socialized with friends at a tavern. If that is evidence of premeditation, if that is incriminating, then surely the opposite is maybe not completely exculpatory, but it's something that a jury is entitled to consider. If he was saying, I'm happy this happened, I'm calm, there's nothing wrong, I wish they hadn't caught me, but it's no big deal, the state would be jumping up and down about that when he is...
Okay, I haven't read everything in this record. Was there any evidence at all about his conduct in Kentucky, about how upset he was? Was there testimony to that effect?
There's testimony from the officer who goes and talks to him, and he gives a statement that is, it's sort of a bizarre statement in which he's talking to the officer about how the officer's dealing with women well, that he got divorced or something. There is nothing about this kind of heart-wrenching remorse of what have I done, of I've killed my baby girl and she didn't deserve it. I think that did not otherwise come into the case.
Now, in spite of the fact that, you were talking about the record, I assume the nurses were not called as witnesses?
That's true.
Because the nurses could have testified about the way he was acting in front of them, not necessarily what he was saying, if there was a hearsay problem, right?
That's right. I do want to turn to the issue that's raised in the motion for new trial. This is awkward in the sense that I have a great deal of respect for the trial judge. I'm sure you do as well as your colleague now. And I can only say we all make mistakes. And this was a mistake. The facts that came out, to the extent they came out in the motion for new trial, defense counsel says, we have learned after trial from a court officer that during the deliberations about 2 hours one day, 11 hours on the second day, that during deliberations on the second day, the jury asked to go home for the day. And we have learned that you, the trial judge, did not allow them to do so, and they subsequently returned a verdict. And that no one told us this. So none of this on the record, none of this even off the record. It simply was not known to defense counsel until after the trial. At the motion for new trial hearing, defense counsel does what seems to be the eminently reasonable thing of, Your Honor, what happened? And you have this very awkward exchange in the judge saying, I'm not going to put on proof for you. Eventually, the judge, counsel kind of presses, the judges agreed, yes, that basically happened. The jury asked to go home, we had started ordering them food, and I told them they're going to keep deliberating. There's no, the judge sort of said, I'm not going to give you any more than that. That's all you need to know. I don't think there's any prejudice in end of inquiry. So we don't know a lot of things about this. We don't know, was there a note passed? We don't know if this is a judge talking directly to the jury. We don't know if the judge just said, food's on the way, you can't go home, or the judge said, you have to keep deliberating. We don't know a lot of things about this. We've raised three, I think, claims about this. First of all, the shortest one is, I have never seen, I could not find a case where a jury requested to essentially recess their deliberations for the day where the trial court refused that. The second and even more important issue is this is something absolutely has to be done on the record. When you are, this is not just the judge saying your food's coming. This could have been, the jury could have received a number of messages from how the judge answered their question in terms of, judge isn't happy we don't have a decision yet. Judge isn't going to let us go home tonight if we don't get a decision. We don't know how that would have been interpreted. The reason we don't know is because we don't know what the judge actually said to the jury. And the reason we don't know what the judge actually said to the jury is because defense counsel wasn't there. Absolutely, when you're telling a jury that wants to go home and come back another day, that they can't, they're not allowed to, they have to keep deliberating, that is something that can have an effect on them. This is not administrative, the bathroom's down the hall. This is something integral to the deliberations. They're being told that what they want to do, what they think is right. Apparently they think they're tired, they think they can't get any further today. The judge is telling them, nope, you have to keep doing it. And it's happening off the record. That is error in and of itself. Because we don't know what was said, we can't say that that was harmless. And it is something that was capable of affecting the deliberations. Finally, if there is a problem in the sense that the appellant can't say exactly what it is that was problematic that the judge said, that is a problem that the appellant did not cause. He wasn't there, didn't know about it. He went to the source at the motion for new trial hearing to ask the judge what actually happened, and the judge declined to answer those questions and give that information into the record. So for those three reasons, we think there was error in the handling of that issue. I will otherwise reserve my time for rebuttal.
Certainly. Good afternoon, Your Honors. May it please the court. Garrett Ward here this afternoon on behalf of the state. Your Honors, I will spend my time before this court addressing the same issues that opposing counsel has. Obviously, if there are questions about the other issues, I'm happy to answer them, but I intend to rest on my briefs for those. Turning first to these hearsay statements, Your Honors, I more or less agree with opposing counsel's characterization of what these statements were. They're reflected in, I believe it's Exhibit 7 and 8, are some notes taken by a nurse at a medical facility in Kentucky. The defendant says a whole lot of things. He admits to killing the victim. He accuses her of cheating on him. He does seem to express some amount of regret for having killed her. Make statements about, I've ruined my life, I've ruined my son's lives, I can't believe I did this, it's actually my son's birthday, can't believe I did this on his birthday. Your Honors, these statements are, the defendant's statements, I mean, because I don't sort of dispute opposing counsel's characterization of the medical records portion of these passing the hearsay test. But the defendant's statements themselves are just hearsay that does not meet an exception. Defendant seems to be making two principal arguments at this point as to why these statements may have possibly met some hearsay exception. And the first is excited utterance. Judge Wilson, you were correct to note that there was not an insignificant amount of time that passed here between what I understand the startling event to be, which is the defendant murdering his wife, and the statements being made. It's 5 to 6 hours. And my friend on the other side is right that we do know a great deal about how he spent those intervening hours, and I think all of that is important. Certainly there are times in these intervening hours where he does seem to be sort of beyond making sense. A conversation with his mother that took place within like an hour or so. After the shooting, she talks about him behaving like a child. There's this conversation with a coworker. But we're not dealing with those statements that were made an hour, 30 minutes after the shooting. The fact that he was upset when he talked to his coworker and when he talked to his mother don't really have much part to play in how upset was he when he was at the hospital. What I want to note for the court is some things that happened in these intervening hours that I do think have a rather large part to play in, is he still laboring under the excitement from the startling event? Because that's obviously more or less the language of the hearsay exception. Is the declarant still laboring under excitement from the shooting of his wife? Is essentially the question that the trial court was faced with. Well, in between the shooting of his wife and this and these statements being made, a number of important things happen. For one, the defendant goes and buys, he buys some clothes at Walmart and seems relatively even-keeled on the surveillance video. More importantly, he stops at a liquor store in Rocky Top and buys a pint of what appears to be whiskey, and from our record, it seems like he consumes some of it and is inebriated when he ultimately crashes his car, which brings me to another thing that happens is he flees from police and has a car accident. So a great deal of startling, emotional things that would have an emotional impact on the defendant happen in these intervening 5 hours. So that brings us to him making these statements at the hospital. The statements, again, are largely recorded in notes. For the most part, the recording that these nurses did does not make a great deal of mention of how exactly the defendant was behaving when he began talking to them. I'll admit that I believe both nurses, when they're recording his statements, do mention that that at some point during the statements, I believe in both instances, it's toward the end, the notes reflect that towards the end of these statements, he does begin crying. But really beyond that, we don't have very much, and we certainly don't have much that ties the defendant's crying to specific, him still being so startled by this event. A lot happened to him in these 5 hours. He had a car wreck. He is sort of, drinking. A lot happens to him, and you don't have much to connect his behavior to the startling event of the shooting. And what we do have about his emotional state, period, is just he was crying, essentially. And Your Honors, that's simply not enough to show that he's still laboring under the excitement from shooting his wife. This just wasn't enough to establish that. There are other things the defendant could have done. I believe, Judge Wilson, you asked if the defendant called either of the nurses. No nurse was called. They certainly could have provided more context as to how he was behaving throughout the entirety of these statements. That's really the evidence that's missing from this record that the defendant would need to satisfy the hearsay exception for excited utterances. Your Honors, turning to the sort of then existing state of mind, to be candid with the court, I think this is a bit of a closer call in the sort of numerous statements the defendant makes to these nurses. Some of them do seem to be at least arguably relating how he was feeling at the moment he was making these statements, expressing regret, sort of contemplating the impact that this is going to have on his life. It's arguable that some of those statements maybe are reflections of a present state of mind. Some clearly are not. Defendant's statement accusing his wife of cheating on him is just a statement accusing his wife of cheating on him. That's not his state of mind. It's an accusation. His statement admitting to killing her is just a statement of fact. So, well, perhaps some things that he says at the hospital are at least arguably present, sort of present sense impression states of mind. Much of it really isn't close at all. A lot of these statements are just him reciting what happened earlier in the day, and then sort of assigning some blame to what happened earlier in the day to his wife. Those aren't present. They're then existing states of mind. They're just essentially statements of fact. But in any event, Your Honors, where I think we need to go next is, were these statements harmful? And I'd contend to this court that they were not. There is a pretty compelling case of premeditation in this case, albeit one that is circumstantial. This isn't, as with most cases, there's not sort of a notebook out there that's introduced at trial that says, I'm going to kill my wife. The evidence here is circumstantial for premeditation. And I want to focus on premeditation because I think that's defendant's argument for why this might be harmful to me seems to be, these statements I made that were made at the hospital of my state of mind 5 hours after the shooting have some impact on premeditation because they show that I wasn't calm after the killing. And maybe there's some relevance there to Bland, or under Bland, because, calmness after the killing is a Bland factor. But what I want to direct this court to is all of the other Bland factors we have in this case that present a pretty ironclad case of premeditation. So I think to discuss this, I'll have to discuss the specific logistics of this shooting for just a little bit, if the court will indulge me to discuss the facts briefly. There's a long, protracted argument between the defendant and his wife that starts in person at a roller rink, continues via cell phone while the two of them are driving separate cars to the same location, and then continues at this ultimate location. The defendant parks himself next to the victim's car. Their cars are parallel, but aligned sort of head to tail. So the driver's side, the front of one car is at the tail of the other. The defendant gets out of his car and walks to the front window of the victim's car, and they argue for some amount of time. The victim at this time is essentially trapped in her car. Her keys are with her child, who has gone to the apartment to get something because they've got to go run another errand. So the defendant and the victim argue for some time at this window. At some point, the victim wants to disengage from the argument, so she goes to roll up her window. The defendant then punches her window out. The victim asks, or tells her child, who's at this point returned, tells him to call the police. The defendant sort of apes her statement back to the child who was there. He then walks diagonally from the front of the victim's car to the front of his car, reaches inside, retrieves a handgun, walks back and shoots her. Your Honors, if two people are in an argument and one of them walks away to go and get a gun and then comes back and shoots the person, that's premeditation. This was a strong case for premeditation. And I say all of that because that's how we have to evaluate, was the exclusion of any of these statements harmful? As I understand the defendant's argument, he suggests they're harmful solely because of some minor amount of relevance they may have had towards premeditation against the case I've just laid out for this court. That simply doesn't move the needle. So if this court is inclined to conclude that some of these statements met a hearsay exception, I would urge this court to conclude that the erroneous exclusion of them was harmless because the state's case for premeditation was so strong here. Turning, Your Honors, to this, I think I agree with my friend on the other side, a bit of an unusual issue regarding jury deliberations. What the record reflects is that at some point during the second day of deliberations, the jury conveyed a message to the trial court that, asked to go home. This record doesn't reflect exactly when this message was conveyed. And the trial court responded, and this is all in volume 13, Your Honors. It's the motion for new trial hearing. I believe it's pages 12 to 14 are the most pertinent discussion. And the trial court, says on the record that the jury came out, asked to go home, and he told them, we've already begun ordering dinner, so we're going to continue that process, and then the jury continued deliberation. On this record, Your Honors, we don't really have anything from the trial court beyond an administrative duty. This is just a comment about, is the jury going to sort of continue what it's doing? There's nothing in this record that suggests a supplemental instruction that suggests anything more was said than what the trial court said that it said on the record. And if this communication is administrative, then it wasn't improper for the trial court to have done this. Now, as I see opposing or defendant's argument, to some degree, he wants to raise the idea, raise the specter that something else happened, something more than what the trial court put on the record. I do want to be very clear for the court. The trial court does state for the record essentially what happened. at least insofar as what it said to the jury. So it seems like what defendant wants to do is suggest that something more happened, sort of raise this idea that there was something inappropriate, something malicious, something untoward that happened during this communication about ordering dinner. Your Honors, there's nothing in the record to support that. And I understand that opposing counsel's argument, as I understand it, is that the reason that this isn't on the record is not the defendant's fault, that there is nothing more he could have done to have developed the record on what happened on this second day of deliberations. And respectfully, Your Honors, I just disagree on that point. I think there's a great deal that defendant could have done at the motion for new trial that he didn't do, that would have developed this record and maybe would have uncovered whatever malicious or untoward or improper thing he seems to be suggesting may have happened. He easily could have called at the motion for new trial, easily could have called the court officer or bailiff who apparently informed him that the jury had this question. That person would certainly have been able to provide some testimony, at least about the time this question was made, would have been able to provide really important testimony about, was this sort of a formal jury question in the form of a note that was passed to the judge? There's nothing in the record that suggests that this was sort of the most classic formal jury question. The court officer who informed defendant that anything happened would have been a really excellent person to call to develop these facts. And the defendant chose not to do that. So the record doesn't speak to that, and the blame for that lies at the feet of the defendant. There are people he could have called to develop the record on this point, and he didn't do it.
Is that pretty much all we have? 3 pages in volume 13? Is that all there is on this issue?
Maybe a couple on either side of that, Your Honor. But no, there's not much more than that.
There's not an affidavit or anything?
No, there is as I recall the record, essentially what happens is we're running through at trial, the state and the defendant are running through arguments on the motion for new trial. We get to the motion for new trial argument regarding this jury deliberation, and defendant's trial counsel asks of the trial judge, sort of tell him what happened. The trial judge, I think, is understandably a little reticent to put facts on the record. It's generally disfavored by Tennessee's rules of evidence for trial courts to do that. But ultimately, he does, as I stated to the court earlier, put on the record the communication it had with the jury. And that's really the end of it. Certainly, the court didn't do anything to prevent the record from being developed further. But no, we don't have a lot. That's more or less how this issue was developed at trial. There could have been further development. Maybe that further development would have provided something that helped the defendant's position, but he must bear the fault is his for not doing this. There are people he could have called that would have meant there were more pages in the record devoted to this, and he didn't do that. Unless there are further questions from this court about these issues or the other issues in the case, I would ask that you affirm.
All right, thank you, General.
Thank you, Your Honors.
Mr. Harwell, I don't want to disrupt your flow, but would we be in a different situation if the exact same scenario with the exact same facts had happened with the dinner breaking for the day, and the trial court had denied any request to adjourn and they kept deliberating? Would we be in a different situation if the court had taken the same action by notifying the parties?
I might still have an argument that they should have been allowed to go home, but the essence of the argument, I think, is that juries are very susceptible, and that is why we don't communicate with juries without the parties being present, or at the least as an absolute fallback without telling them what has just happened.
Well, on the first part, the court communicates with the jury. I guess they could show them a copy of the note, but the parties aren't even there when that communication is typically done in a trial, right?
I think the proper procedure, if there's a note, is the note gets passed to the court shows the parties the note, and parties have an opportunity to discuss what a response is going to be.
Okay, let's say they want a smoke break, something like that, and there's a note passed, and the court says, hey, we're going to break for lunch in 20 minutes, keep deliberating. Situation like that.
I think a smoke break, there's this administrative exception. I think a smoke break is probably an administrative exception. I think when you have a jury saying, we've reached our limit for the day, we want to go home, something to that effect, they're asking to go home, and the answer is going to be, no, you can't. That is, we have to be very worried. How are they going to take that? Is that going to be are they going to interpret it one way or another? Do they think that means the judge thinks they should have reached a verdict already? The judge is putting pressure. We have to be very careful because that could influence the jury. That has to be on the record.
So the jury, are you saying that the jury said that we've reached our limit, we want to go home? Is that what they said?
We don't know what they said.
Okay, well, then let me ask you this. Why wasn't the court officer called as a witness?
I don't know. I don't know. Would the court officer have been allowed to testify? Would he have heard? I don't know.
Well, I don't know, unless that inquiry is made. And that's the thing is that, they're obviously, usually, at least the way it seemed like to me, is that the court officers would sometimes get word from somebody, hey, we need a smoke break or something like that, and the court officer would come to the court and say, looks like they need a smoke break. Or sometimes you get a note. Of course, the notes usually always got filed with the clerk and were put in the jacket. But there's some officer there that would have seen something or heard something that could have provided this information to this inquiry. And I'm just curious why somebody wasn't called, or at least there was an attempt to call somebody, other than just asking the judge.
I think, honestly, it is my expectation that it never crossed defense counsel's mind that the judge was not going to answer. I mean, defense counsel says, were they given a note? Did you pass information to the bailiff? Judge says, I'm not going to put on proof.
Okay.
But the judge knows.
Well, but also other people know. And that's what I'm saying is, I think, that would require the lawyer, I think, to increase, to broaden the inquiry. And not just say, Judge, what did you do? Well, then, Judge, if you're not going to, it's like, basically the judge is saying, find other proof. Find another witness. Call who else was in the courtroom. I mean, that seems to me how you get your proof.
You can't call the jurors.
No, but I didn't say the jurors. I said,
And I don't, this may be entirely hearsay for the bailiff. The one person that absolutely knew what happened is sitting in the courtroom.
all right. And I guarantee you, there was probably somebody else there that could also testify. And it's just like, there was never an attempt to analyze that. That's the question I have is, there were probably other people there that could have testified.
I think it's quite possible. I do think that absolutely it was appropriate to make that request of the trial judge. He knew what happened, and he refused to provide that information. I think that is a serious due process issue for him to keep that information to himself. If I could just very briefly have the court's indulgence to address the statements issue. I don't want to repeat the evidentiary argument, but on prejudice, the state has said this is an overwhelming case of someone getting a gun and intending to kill someone. The issue, are they sufficiently free from excitement and passion, divides first degree and second degree? That is always a very subjective decision. I have cited in my brief, and this is not because it's a sufficiency issue, but I've cited in my reply brief a number of very similar cases where the jury returned second-degree murder verdicts. Defendant retrieving a gun from a vehicle, defendant being asking someone and getting a gun handed to them to engage in the shooting. This is a prototypical issue of it's going to be to the jury whether it's first degree or second degree. There was information that under Bland would have been helpful for the jury to consider. It was, I think the state has not quite conceded, but almost conceded it should have come in under 8033, and we believe that was not harmless. Thank you, Your Honors.
Did you say everything you wanted to say? Because we took up a little of
We
your
interrupted
time.
you.
Yeah, I
That's
want to be
okay.
sure.
I probably said too many things, Your Honors.
Okay, all right. I want to be sure you felt like you were fairly heard. Excellent. All right, thank you both. Good briefs, good arguments. We'll take the case under advisement, and we start up again at 9:30 tomorrow morning, so we'll be in recess